Okay. I want to welcome all of our attendees today to our presentation of the 2023 legislative changes to the Maryland divorce law and practice tips. We are so glad that you can be with us today, and we are so grateful to have Magistrate Ginina Jackson-Stevenson here with us today to provide some information on this topic. As you all know, there were some rather significant changes to the divorce laws that went into effect this year. And I think we're all learning together on, how the courts will be handling some of those changes. And I do want to thank you for being connected with MVLS. If you, as a volunteer, for those that I see online who are our volunteers, if you're thinking about becoming a volunteer, I'll talk about that a little bit after the presentation concludes about how you can do that. So I just want to start, just kind of give a brief introduction of our speaker and of MVLS, and then I'll turn it over to Magistrate Jackson-Stevenson for the bulk of our presentation. If you have any questions today, I would welcome you to enter those into the chat, and we will handle them at the end of the presentation. So that's how we'll handle any questions today. Let's see, I'm sorry. I think I meant to be showing the full slides on my screen, and hopefully, can you see the slides, Magistrate?
Yes.
Okay,
Yes.
excellent. Okay, so just really quickly, MVLS family law is the biggest area in which we serve clients. We get far more requests for custody and divorce case representation than any other area that we serve here at MVLS. Who are our family law clients? Most of them are the working poor, people who work, oftentimes several jobs. Typically with our divorce cases, the house is, the only major asset if the person does have a house that's involved. And oftentimes we do serve clients who are leaving abusive situations. Most of the people we work with have had either little experience with the legal system in the past, or sometimes a negative experience with the legal system in the past. And so I think that's very helpful to keep in mind as you, our volunteer attorneys, are starting to work with our clients. And you are, you are doing us and our clients a great service by stepping up and being their pro bono volunteer to, give them a positive experience with the legal system and what the legal system can do for them. As I'm sure you have all experienced pro se clients, on the other side of some of your cases, it is very hard to succeed as a pro se client in court. Clients don't know how the law works, how the procedures work. And so you are really giving them a huge leg up by taking one of these cases through MVLS. And I would say for the, our clients otherwise would very likely go to court unrepresented. So that's kind of a very quick introduction about why we do what we do here at MVLS. And we are delighted to have Magistrate Ginina Jackson-Stevenson here today to present on 2023 legislative changes to Maryland divorce law with practice tips. She is well versed in family law issues, and we are very grateful for her to be sharing her knowledge on this topic. She is a family magistrate on the Circuit Court for Anne Arundel County. And she was appointed on August 12th, 2020. She currently serves in the family division and presides over divorces, child custody, visitation, and child support cases. Prior to her appointment as a magistrate, she operated a solo law firm for 10 years, and her practice primarily handled family law matters, criminal cases, personal injury, and police misconduct in state and federal court. Prior to that, she served as a criminal defense attorney in the Office of the Public Defenders. And she has also served as an adjunct professor at the University of Baltimore Law School. She is also an active member of several bar committees. I want to thank her again for being here today and turn the presentation over to her. Thank you.
Well, thank you. It is my pleasure to be here to help guide us through all of this. This is with new changes with the law, as with everything, until there is case law that comes down, we're not quite sure what guidance we're going to have. So this is definitely uncharted waters for us as judicial officers, and it will be for you. So hopefully at the end of the presentation, I will have answered a lot of your questions. But if not, feel free, as Ms. Hennis said, feel free to ask them, and then we'll go from there. If I have answers for you, I'll give them to you. If I don't, I'll tell you. I can research and let you know. But right now, we do have the legislative changes that have happened, and we'll move forward from here. So next slide. So this year, there were several changes that were made in the family law division, or in family law. So there were 5 changes. However, today our focus will be just on the laws that will affect the custody and judicare attorneys. Next slide. So we're going to go through what the current law is as of now, because we have until September 30 that many of you may have court appearances on. So we're going to go from where we are now, and then we're going to travel to where we're going to go in the future, uncharted territories. Next slide. So currently we have family law article, which is our limited divorce, which is 7102. And of course, the limited divorce was more geared toward a separation. So the limited divorce really could be interpreted as a legal separation between the parties, because they were not, their marriages were not terminated, but there was an order that would have been given so that the parties could then operate basically, as I said, as legal separation. So those grounds that we could use and are still in effect is the cruelty of treatment, the excessive vicious conduct, desertion, and separation. And the court at that time could decree a divorce under this section for a limited time or an indefinite time. There are many litigants who get the limited divorce, or were getting a limited divorce, and didn't realize that they weren't legally divorced and that their marriage had been terminated. Excuse me. And there were some that would come back several years later. It could be 6. I've had some that have come back 10 years later with their limited divorce, and at this point in time, they were asking for an absolute divorce. And here at the last part of this is, if an absolute divorce is prayed and the evidence is sufficient, then we could, at that time, if it was sufficient, could have them to amend, and that they could have an absolute divorce at that time. Next slide. So what we have now is our absolute divorce, which is family law article 7103. That one, as we stand today, there are 8 grounds. So we have the adultery, and we have desertion, the conviction of a felony or misdemeanor, the 12-month separation. Next slide. Sorry. 12-month separation, insanity, and then we have cruelty of treatment, excessive vicious conduct, and we have mutual consent. So we're going to sit here for a minute, because a lot of times what we see here in Anne Arundel County is that the parties or the attorneys will present their marital settlement agreement. However, if they have children, they neglect to put the other parts to it. So there are 4 parts that can, or 3 parts that need to be resolved with the mutual consent. And that's, again, they have to have the written settlement agreement signed by both parties. And we've had people come in that only one of the parties has signed the agreement and want a postponement so that they can, or we can submit it later. So make sure that you have the agreement signed by both of the parties. And in the agreement, make sure that you have alimony has been dealt with, the distribution of all of the property, whatever it may have been, that it has been resolved. And then, which is most important, if there are minor children, that the care, custody, access, and support of the minor children has been outlined. It could be in the marital settlement agreement, or it could be in a separate document. A lot of people use the Maryland planning tool, or Maryland parenting planning tool. A lot of litigants use that, or they could have a separate agreement, but it doesn't matter as long as it is determined in the agreement. Now, what also needs to be attached to that is the child support guidelines worksheet. So that's where a lot of people get stuck, because they have not attached the child support guidelines worksheet. So make sure that you attach those. And if you're requesting, and this is the most important thing, if you're requesting and the parties have agreed that they want to be generally charged, then there has to be consideration for why the parties want to be generally charged, or why there is a downward deviation in the agreement. A lot of times litigants come before us and they say, well, we've agreed that we don't want each other to pay child support. Well, the law doesn't allow that unless there's consideration. So please, 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 please make sure that you put in that if there's a downward deviation, why? What are we to consider? And here in Anne Arundel, we ask that the amounts. So if it's $1,000 and you want to be generally charged, then what is that other party, the due and owing party, what are they paying or covering that will amount to the $1,000 that is owed? Again, the last part is neither party files a pleading to set aside the settlement agreement prior to the divorce hearing. Oftentimes we have people come in and say, well, we don't want to move forward, or I don't want to move forward. I don't agree with this settlement agreement. Well, this is the date of hearing. As you see, the statute tells us it has to be set aside prior to the divorce hearing, which is required under Maryland rules. And then after reviewing the settlement agreement, the court is satisfied that any terms of the agreement relating to the minor children are in the best interest. So that's always keeping in mind that it's in the best interest of the children that you make sure you outline why there's a downward deviation. Next slide. So I left this in here because these are what, as the law exists now. So we have the recrimination and the res judicata and condonation. So, and that's where we are today. Next slide. And then a court may decree an absolute divorce even if a party has obtained a limited divorce, which we talked a little bit about earlier. If a party obtained a limited divorce on the grounds of desertion that at the time of the decree do not meet the requirements of the subsection, then the party may obtain an absolute divorce on the ground of desertion when that time frame has occurred. Next slide. So G we'll touch on a little bit, and then we'll go forward to what we are headed to. So for purposes of this subsection A4, the filing of the application for divorce, and this is what a lot of times attorneys are not aware of, that the filing of the application for a divorce includes an oral amendment made by a party with the consent of the party at a hearing on the merits is open. In open court can be easily said is that it can be amended in court, even if it's a limited divorce, if the parties have and the time has elapsed. So you can make oral amendments to your pleadings during your court proceeding. Next slide. So the laws that are effective going forward as of October 1st of 2023. All right, hold on. Family law article limited divorce is now eliminated. Limited divorce is eliminated. The legislature saw fit that there was no need for a limited divorce So it is now gone. Next slide. We get down to absolute divorce. So we are absolute divorce. We see now that all of the grounds for absolute divorce, except for one, remains. Next slide. Next slide. And then we get to the next slide. So even under the additional rules that we have, or the subsections of the statute, condemnation is now gone because it's on the grounds of adultery. So that's now no longer relevant because adultery has been eliminated as a fault grounds for divorce. Next slide. And again, we come to this where a court may decree an absolute divorce if the parties obtain a limited divorce. So what you will see when you review the coming statute is that, or as you review what the legislature has done, all of anything related to adultery or cruelty of treatment, all of those have been eliminated from the statute.
I think I may have gone forward too many slides sorry, you're on the one that is
E1.
section E.
Yes.
Okay, sorry, I went forward too
okay.
much. Okay. Do you want to go to the next slide, or are we on
Yes.
this slide? Okay, great.
We can get to the next slide.
Okay.
So with subsection E, this still remains in part. The only difference that was made to this is that the slightly changed to correct the letters. So it now becomes E and no longer F. So if the court decrees an absolute divorce on the grounds of mutual consent under subsections A3 of this section, the court may. So all of that still remains. So that's helpful to know going forward with the mutual consent, that all that still remains, that the agreement can be merged or incorporated into the divorce decree and modify or enforce the settlement agreement consistent with Title 8 of subsection 1. Next slide. Again, with G, that has now changed to E, and it's added in there that it's filed application for limited divorce filed before October 1st. So what this allows us to do is that if a limited divorce was filed before October the 1st, that it can then go forward to be an absolute divorce. So the October 1st, 2023 was added to the subsection to accommodate the changes. Next slide. So what remains, and what remains from the prior statute, from the current statute until October 1st, is that mutual consent. That's it. So that remains in its totality as it is written. So those that are comfortable with mutual consent become more comfortable with mutual consent because it's going to remain the same. And again, I cannot emphasize enough to be well-versed in the mutual consent, because oftentimes litigants and attorneys have come in unprepared with everything that's needed for the mutual consent. And they look surprised when they haven't dealt with alimony or the distribution of the property, and the court is denying their request for divorce because they haven't complied with the statute. So please be aware, and very importantly, again, with the child support guidelines, I can tell you it's a little easier with the guidelines not attached because that can be done in court, but we really prefer, especially here in Anne Arundel, when we have an uncontested docket. So let's pause for a minute. Here in Anne Arundel, we have an uncontested docket, which comes up. So I have it on Tuesdays, but on the uncontested docket, everything is supposed to be resolved and everything is supposed to be submitted prior to the hearing. There's a little leeway given by us as the magistrates because we understand that what the parties' desires are as far as submitting the documents prior to the hearing, but that is not something that we prefer. and it's depending on who you're in front of, they may or may not accept the documents. So when I say documents, I'm talking about the marital settlement agreement, if there were amendments to it or supplements to it. Each jurisdiction is different, and I can't express that enough. Each jurisdiction is different. So each bench may do things a little bit differently. Here in Anne Arundel, we have an administrative directive that we cannot deviate from the guidelines unless there is consideration, which isn't consistent with the law. But be sure that if you're going to a jurisdiction that you're not familiar with, contact one of the local attorneys and ask them, what is the court's preference? How does the court want to proceed? So that's always helpful also, so that when you get in there, you're representing your client and you want to make sure that you put your best foot forward. Because if not, what ends up happening, you look like you don't know what it is that you're doing, and you never want to be able to do that or be ostracized by the court because you're not properly prepared for that particular jurisdiction. Right, next slide. So our new state of affairs and moving forward. There now exists 3 grounds of divorce: 6 months separation, irreconcilable differences, and we have our mutual consent. Next slide. So you'll see there are no, there on these slides, there are no designs or anything because we needed to focus specifically on the statute. So the 6 month separation is pretty much the same as the 12-month. The only difference is the time frame has changed. So if the parties have lived separate and apart for 6 months without interruption before the filing of the application for divorce, next slide. So they can, the filing can be submitted. We have irreconcilable differences, and the statute reads, based on the reasons stated by the complainant for the permanent termination of the marriage. What does all of that mean? So that's what does all of that mean? So we'll get to that in just a few moments, but just marinate on that for a minute. Based on the reasons stated by the complainant for the permanent termination of the marriage. So what I will say right now is that it's very, very, very subjective. There is no objective standard like we have in the next slide, which is mutual consent and 6 months separation. All right, next slide. So 7103B also changed. So that one says parties who have pursued separate lives shall be deemed to have lived separate and apart for purposes of subsection A1 of this section. So that's dealing with the 6 month separation. I know one of the questions that was presented was, well, how is that defined? So 7103 gives us further detail or further instruction on how we can determine if there was with the 6 month separation. So the parties have pursued separate lives. What does that mean? Again, that's a subjective standard, but make sure that you let us know at the hearing why the parties were living separate lives or how they were living separate lives. And it could be under the same roof, or they could be separated in accordance with a court order. So maybe there was a protective order that said that the parties had to live separate and apart. So that that is an additional factor to take into consideration as well. So I'm gonna stop there for a moment. Are there any questions?
I do see some questions in the chat, so let me just check what, okay. One of them was just procedural about getting access to the slide deck. And I should have said at the beginning, this will be recorded. And yes, we will share the slide deck. And I think this slide answers this next question. With 6 month separation, can parties still live under the same roof?
Yes.
And yep, I see that.
Right.
Someone asked if they are amending after 10-1, do we lose the fault-based grounds?
Hold on to that question.
Okay, we will come back to that question.
Yes, we will
Um,
come back to that question.
and I thought I saw a raised hand, but I don't see it anymore. So if you did raise your hand, please do put your question in the chat, but that's all we have for right now. Thank you.
Okay, great. And then 703F, we talked about that just a few moments ago. And that is just, they added to the statute filed before October 1st, 2023. So that's the only amendment that was made to that statute or that subsection. Next slide. Now let's dissect all of this. So let's take a look at it and see how we're going to go forward. So 6 months separation, if the parties have lived separate and apart for 6 months without interruption before the filing of the application for divorce. We've talked about that and how that's going to apply where it was 12 months before. It virtually remains the same. 703B, we've talked about this one too, and the parties living separate lives. So yes, they can live and still reside under the same roof. We have a lot of that coming in where people are doing mutual consent and they still live under the same roof. A lot of times it's the parties believe that it's easier for them to still live together, especially when they have minor children. So a lot of times it's financial reasons, and it could be reasons for the children that they stay in the home and live together, and they live in separate parts of the home, presumptively, and they're still residing and taking care of the minor children. And then this one again, the only change is before October 1st, 2023. Irreconcilable differences. So let's go over this for just a moment again. So with irreconcilable differences, we end up with, it's based on the reasons stated by the complainant for the permanent termination of the marriage. So because this is a new law, there's going to be a wide variation of how it's going to apply. It's going to be very, 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 very different in how it's going to apply. So when I looked at this, of course, I had to go back to use something in law school. If you're not quite sure, where do we start? Black's Law Dictionary. So next slide. So when I looked at Black's Law, it said irreconcilable differences. So that's a no-fault ground for the dissolution of a marriage under many state divorce statutes. That really didn't help. So then I said, well, let me look a little bit deeper. And then it sent me to irretrievable breakdown of a marriage. Now that gave me some meat. So I had a little bit of meat on the bone. So as of a irretrievable breakdown of a marriage is defined as a no-fault ground for divorce. And that means a condition in which either or both spouses are unable or unwilling to cohabit as husband and wife, for which there are no prospects for conciliation. So that was important for me to start at the beginning, just to see where and how Blacks defined it. And then the next step, what do? We go to other jurisdictions. Next slide. So in New Jersey, which has irreconcilable differences, they have a self-help guide on divorce. So what they said is that the complaint can be based on irreconcilable differences, and you or your spouse, one, they have to meet the residential requirement, which is Maryland has 12 consecutive months preceding the filing. You and your spouse must have experienced irreconcilable differences for a period of 6 months, and the irreconcilable differences make it appear that the marriage should be dissolved, and there's no reasonable prospect of reconciliation. And what New Jersey does is they said that there's no need to accuse the other spouse of any wrongdoing. So it doesn't have to be a reason for wrongdoing. It could be just as simple as we just can't get along. So, and it does say that if you do provide a ground, that it doesn't improve your chances of getting more child support, more alimony, or other financial arrangements. such as an equitable distribution. Now that's New Jersey. So I wanted to do East Coast. Next slide. And then we move to the West Coast, see what California is doing. So in California, irreconcilable differences mean that at least one party asserts that the marriage cannot be saved. And California, as in New Jersey, said the proof is based on a statement by one of the parties and does not require other proof. So in both of those states, they don't require proof. There's no proof to be had. So what does that mean for Maryland? Next slide. There is one case law, we'll do the middle of the country, and that's in Ohio. The court ruled that the lower court did not abuse its discretion by granting a divorce due to incompatibility when both parties gave testimony in which they agreed they were no longer compatible. So you have both of those. So if you end up in an uncontested case, or if you end up in a contested case, this gave a little instruction on how to handle that, how to handle irreconcilable differences when it's pled. Next slide. Again, what does this mean for Maryland? So I cannot express enough caveat, caveat, caveat. All jurisdictions are different. All jurisdictions are different. So we have no idea what Anne Arundel is going to do. We're dealing with it. We have no idea what Baltimore County, what Allegheny County, Washington County, Howard County, we have no idea. Each jurisdiction is different, and each judge is going to apply this differently. What I will suggest is that, next slide. What I will suggest is that as far as your practice tips are concerned, identify the issues and differences that the parties experiencing in the marriage that cannot be resolved. So why do the parties say that their marriage is irreconcilable? Identify that issue and why it cannot be reconciled. Why? So what is it? So identify the issues and then identify that the issues cannot be reconciled. And then identify what makes the marriage irreconcilable. And then lastly, and this is a practice tip for whatever it is that you're doing that requires a person and you're appearing in court, prepare your client and let them know that this is what you'll need to testify to. What is their testimony going to be? And make sure that it supports their pleading and the grounds for which they're asking for. As we saw earlier, New Jersey, California, all they said is just a statement that says that it's irreconcilable. That's what it says. So maybe that'll be sufficient. I don't know, but I can tell you here when we've been discussing it, this is just practice tips to help if it is a contested hearing or if it's uncontested, to make sure that you prepare your client to provide what is the testimony to support why they're requesting the divorce. Next slide. So one of the questions, and that's why I said we'll hold on to that question, is that will prior fault grounds serve as a reason for irreconcilable differences? So it's likely yes, that it will. Adultery, desertion, conviction with a jail sentence, cruelty, excessive vicious conduct, and insanity. Will all of that remain? So, or as a grounds, or can it be used to support why you believe that you're no longer reconcilable, or you can reconcile your marriage? So I would say yes, that it will be, because all of those have grounds. But as New Jersey said, that it's not may or may not improve your ability to be able to get alimony or increase your chances for more alimony or equitable distribution of the property. It's all new ground for us. Next slide. I do want to say, be mindful that the legislature kept the C and D in there regarding recrimination, and that it's not a bar to either party obtaining an absolute divorce on the grounds set forth in A1 through 3. So it's not. It cannot be a defense, you're coming in and saying, well, they did the same thing. And I looked at it as unclean hands. So you're accusing the other party of something or a similar accusation, and it's unclean hands. Well, it doesn't matter. It's not a bar. And then we deal with the res judicata with respect to another ground under this section. It's not a bar to either party obtaining an absolute divorce on the grounds of 6 months. Okay, next slide. Questions.
We do have some questions. All right, let's see. Okay, let me just make sure I start with the ones that we have not gotten to yet. Okay. Do complaints filed prior to 10-1 remain under the earlier statute, or is it converted to the new statute?
I think it's going to depend on the jurisdiction, but it can be grandfathered in because it's at the time of the pleading. So my interpretation is going to be like the other statutes that the other changes that have occurred after something's been filed. So either one could apply.
Okay.
But I would say that if it's based on adultery, since adultery no longer exists, it would have to be, will probably have to be amended, which it could orally be amended in court.
Okay. The next question is, what if the basis for the divorce is abuse? Would that be under irreconcilable differences now?
I would say yes, just based on the cruelty of treatment, or excessive vicious conduct, or there could be a protective order that's in place. It does not. My interpretation would be that it would definitely not bar them from getting a divorce under irreconcilable differences.
This seems like maybe a challenging question. How are separate lives defined if the parties live together?
You can live together in the same house, and you're no longer, maybe one spouse was taking care of all the bills, and now the two of you have decided to split your bills. So I pay half, the other person pays half. They live in two different parts of the home, and they're going about, maybe they're seeing somebody else. Maybe they don't have any conversation with each other. Maybe they don't even talk. So I go to work, I come home, or I go out after work, and I don't answer to you anymore. It's almost like a roommate situation. But you probably give your roommate more respect than you would your spouse that you're divorcing. But at least it's something, you would call your roommate and say, hey, I'm going to be late tonight, or whatever it may be. That obligation, a lot of times people don't believe is necessary when you're divorcing. So that's how I would look at living separate and apart. And we're sharing opposed to us doing things together.
Okay. Thank you. What jurisdictions is the irreconcilable differences language based on? In other words, what would be the best persuasive authorities to look to in the absence of Maryland precedent on this issue?
That is a good question.
Yeah, and I don't know the answer to that either.
Yeah, I would say you can look to, in fact, one of the other magistrates provided something to me prior to us getting started, as we did some research on, I did some research on this prior to, but you can look at, I would say, look at New Jersey, look at California, you can look at Ohio. I've cited some of them in on the slides, and the language is really just what the statute says. I would treat it just like I do the other, if there was adultery. Most of the time when we got adultery pleadings, it would be identified later, additional details would be identified later. It wasn't additional details, but it would say that the party with whom the spouse was having the affair with would be provided later. So the irreconcilable differences I would treat the same way.
Okay. Okay. This question is in new complaints. I'm assuming the person means after 10-1. If irreconcilable differences is sufficient, but you are seeking alimony, where would you assert mistreatment and other factors that are a consideration for alimony awards?
I would use it as a subsection to ask for alimony, treat it as a subsection under the irreconcilable differences. That's what I would suggest.
Thank you. Okay, let's see. Okay. This person asks, should we use the same language for the previous grounds in the complaint? So I think they're asking language that they used to use, I think, before the statute change. Or should we specify actual examples of the behavior that we are alleging irreconcilable differences on?
I think it would go back to what we just said. What I just said is that treat the irreconcilable differences just like you did the other statutes. If the parties were living separate and apart for 6 months, and I would say that parties have events or issues have occurred where the parties now believe their marriage is irreconcilable. And I think that that should fulfill what's necessary in the statute, at least the pleadings. That should get you to the pleadings, and then when you come before the court, it says is based on reasons stated by the complainant for the permanent termination of the marriage. So maybe it is adultery or cruelty of treatment. The person was cruel. We no longer can get along. We no longer want to be married. We no longer want to be with each other, and that should be sufficient.
Mm-hmm. I think you may have answered this question already. The question is, can we amend a prior divorce complaint to one of the new grounds, or must prior grounds still be met because filed prior to 10/1/23?
I think it'd be it's depending on the parties, how they want to proceed. You can amend, you can orally amend. The statute allows you to be able to do that in court if the parties agree. If they don't agree, then that'd be another situation. But you can always, after October 1, if you'd like to amend, you can always amend your complaint just for for purposes of ease. Again, like I said, all jurisdictions are going to handle this differently until something goes up and comes back down, and we get further instruction from one of the appellate courts.
Mm-hmm. Okay. Will testimony or evidence of adultery, cruelty of treatment, etc., still be persuasive in argument for equitable division of property, or will the court not look favorably on this type of evidence and testimony given the statutory changes?
I would err on the side of caution, and I would say provide the testimony and explain why. I'm sure that with the element, again, we're uncertain. Mm-hmm. So in this instance, I would say more is better. Usually it's less is more, but I think in this instance, more will be better because you'll be able to explain why you are requesting the award that you want for alimony, and why you believe that the person should get more of something else. So we'll see.
That makes sense. Okay. How would the court handle a 6-month separation where the opposing party disputes a consistent 6-month separation and they're still under the same roof?
Credibility of testimony. It'll go towards the credibility. Who weighs more? Whose testimony weighs more? If the other person is contesting, it's just like we haven't been living together for 12 months. It's the same way with the 12-month separation. The parties mm-hmm. can say that we've lived under the same roof. but we've been living separate lives. So even though it says separate and apart, we've had some individuals that have come in and said that, this is where we are. But I would say that I would look towards just having the testimony, having your client prepared to say, this is why we've been living separate and apart for the past 6 months, and have the evidence. But other than that, I think it's really going to be based on the weight of the individual, the testimony of the individuals.
Thank you. Someone asked if constructive desertion is still a ground. They're saying that is court-created case law. Is that correct?
There are 3 grounds of divorce that still exist, or 3 grounds of divorce: 6-month separation, irreconcilable differences, and mutual consent. Those are the only 3 that remain. So constructive desertion is no longer listed, even though it may have been court-created. There's only 3.
Thank you. Okay. How do you proceed if one party does not consent to the divorce, so no mutual consent? Guessing you'll have to go with one of the other grounds, but I don't know if you have anything else to add to that. Yeah.
No.
So okay. Let's see. Thank you, everyone. We're getting to the end of the questions. We have a lot of questions. Okay. One of the questions is, I think you answered this question as well, about situations where there's domestic violence and abuse and there's the requirement of 6 months separation. The parties must potentially meet this ground while living under the same roof. Is an initial protective order the answer? I do think you said a protective order would be considered with regards to the question of
Right, that's
separation.
the statute provide. The statute provides for that, where they're supposed to live separate and apart, and as separation is in accordance with a court order. So that's the second part of 7103B. The parties reside under the same roof, or the separation is in accordance with a court order. So if there's a court order that says the parties are supposed to be separated, then that that would suffice for the 6-month separation.
Okay, this person is asking a question about a situation where people are granted a divorce and they are still living together, and how is the court going to resolve child custody if they're still living together?
I'll need more details. I'm not quite sure.
Maybe
if they're living together and resolving child custody, I'm not sure. I need more details.
Okay, that makes sense. All right. Well, that is, I believe, the end of the quest. Let's see. I'm sorry. I think maybe one more came in. Does irreconcilable differences require any period of separation?
No.
And that, I believe, is the end of the questions that have come in. Thank you for answering all of those questions. And thank you so much for being with us today. We really do appreciate it. This was a challenging topic, since there is so much unknown about what different jurisdictions are going to do, what's going to happen, when things go up on appeal. So I do appreciate you. People are saying thank you in the chat. We do very much appreciate you, Magistrate Jackson-Stevenson, being here with us and walking us all through what we know to this point, at least.
Yes, absolutely. Well, I appreciate being able to be here to help navigate through this new law.
Yes.
New law.
Yeah.
And did you want to hit the last slide?
Yes, that's a wrap. I am actually going to just give a little bit more information about MVLS and volunteering before we close up. If you do not already volunteer with us and you are willing to help some of our clients through these new divorce grounds or with another type of case, the way that you could do that is through visiting our website, mvlslaw.org. It looks like this. There is a tab where the little arrow is pointing that says volunteer, and you will just fill out a brief questionnaire about what types of cases you're interested in and what jurisdictions. We very much appreciate your help. We also have something on our website called our pro bono portal, and you can actually see what cases we have available. So as you can see, you can sort by family law if that's what your interest is. You can sort by county, and you will see a little blurb on the cases that are currently waiting. So it's a great way to be able to see, you know, what is available if that's something that you're interested in doing but want a little bit more information. Finally, I just wanted to go really quickly into our Judicare panel, if that's not something you're aware of. Our Judicare panel, our volunteer attorneys represent our clients in contested custody or divorce matters. Our volunteers do receive a low bono fee of $120 per hour for attorney time, $40 an hour for support staff time, up to $4,200 per case. So it's a great way to, you know, help a client who would otherwise not have an attorney. I know these are time intensive, so we do recognize, and that's why it's important to us to be able to provide some low bono rate of compensation for these types of cases. The volunteers that are part of this panel must have 3 years of experience in handling contested custody matters. And I give a contact person. You can contact me as well, but Nancy Grimm unfortunately couldn't be here today. She is our family law staff attorney, and I've given you her email address here. And then I just wanted to highlight that we are always doing trainings on all kinds of different topics, family law and otherwise. We have an estate planning basics training coming up on October 12th. And we have recorded trainings. This one is also going to be on the website, but in all of these areas available on our website. And this is just the link to sign up to volunteer if you've never volunteered before. So with all that, thank you so much for being here. Thank you for volunteering with us. Magistrate Jackson-Stevenson, thank you for giving this presentation. We truly appreciate your time.
You're welcome. It was my pleasure. Everyone have a great day.
Thank you.
You're welcome. Bye-bye.
Bye-bye.